I was before the short adjournment making the point that although Romania and the Commission have asserted that compliance with the security order might conceivably give rise to new aid, there is nothing in the way of evidence or reasoning before the court, or indeed before the court below, to show how the constituent legal requirements of state aid would be met. And the consequence, we say, and this is the reason that I referred to it as a bootstraps argument at the outset, the consequence, if Romania were correct, is that it would, in effect, be open to any, at least public authority, to avoid compliance with this type of court order, simply by asserting that compliance, if an order is made, might give rise to state aid, and that it will inform the Commission under the procedural regulation, and that the standstill obligation will kick in, and therefore the order should not be made. And we say that this would be very unfair, because whereas here the opposing party, does not consider that there's any plausible case why this should constitute state aid, the mere assertion of the fact that it might would be sufficient to defeat the order. And we say that, in fact, the case law of the European courts clearly establishes that Romania and the Commission's argument is incorrect. And I want to take up briefly the Deutsche Lufthansa case, which both my learned friends have relied on. And it's at volume 5 of the authorities, tab 74, and it starts at MS 1254. And I'd like the court please to turn to paragraph 33 on page 1261. I'm so sorry, paragraph 34. It's still page 1261. And the key point that is made is that where the Commission hasn't yet initiated a formal examination procedure, then the National Court is not debarred from reaching a view as to whether something is state aid or not. And we see that very clearly in paragraph 34, which says in terms that in a situation where the Commission has not yet initiated the formal examination procedure and has therefore not yet given a decision as to whether the measures under consideration are capable of constituting state aid, the National Court sees of a request that they should draw the appropriate conclusions from a possible infringement of the last sentence of Article 1083, may have cause to interpret and apply the concept of aid, with a view to determining whether those measures should have been notified to the Commission. Thus it is for those courts, that's the national courts, to verify inter alia whether the measure at issue constitutes an advantage and whether it's selective, and that is to say whether it favours certain undertakings or certain producers within the meaning of Article 1071. And precisely the same point is made in the Lübeck case that was referred to by Mr. Khan this morning. The same point, and I'm not going to turn it up, is referred to at paragraph 29 of that judgment. And the key point here is that the Commission has not opened an investigation in respect of any new aid. All we have is an assertion that it might be new aid. And so there is no duty of sincere cooperation at this stage which binds the hands of the National Court. Far from it. Deutsche Lufthansa and the consistent case law of the court makes clear that it's open to the court to grapple precisely with the question of whether the state aid constituent elements are met. And of course, in this case, no argument has been made by the Commission or by Romania, which is designed to assist the court with that function. And so we say there is simply, not only is there no duty on this court of sincere cooperation to avoid making the security order, but it would be incumbent on Romania and the Commission, if they were to rely on the duty of sincere cooperation, to raise before the court and raise before the courts below the basis on which they claim this is aid, so that we can make arguments in response and the point can be grappled with as is envisaged in these cases. The Commission's failure to take any steps to open an investigation into this new aid also has other consequences, and the Court has seen that of course, the Commission knew about the Court of Appeal's order when it was made, because it was party to the proceedings below. And if confirmation were required, Romania formally wrote to the Commission, reminding it of the fact, and we've seen the letter of August 2018 sent by Romania to the Commission. And as the Court saw yesterday, under the State Aid Procedural Regulation, the Commission has 2 months following notification to make a decision. And where it hasn't made a decision, then it's deemed, the aid is or the measures deemed to be lawful. And we see that from paragraphs 4, subparagraph 4, 5 and 6 of the procedural regulation, which the Court looked at yesterday, and I won't turn up again. And so we say, essentially, that the short point is that the Commission has been seized of this matter. If it wanted to make anything of this point, then it was incumbent on it to actually open an investigation. It hasn't done that. And in those circumstances, the point doesn't go anywhere for the Commission or for Romania. And finally,
just on that, I think that the answer given on the other side was that it's not a plan of Romania to give state aid, because it's not going to act until the obligation imposed by this court kicks in. What do you say about that?
My Lord, not a plan of Romania to give state aid, so a plan of...
So from my recollection of the argument, and we haven't got the yes. Procedure regulation in front of us, is that there has to be notification of plans for state aid.
Ah, I see.
And then the regulation for obligation on the Commission to take 2 months to say whether it's going to object applies to that. And I thought that the answer given on the other side as to your point on Regulation 4 was that at this stage, Romania, if you like, isn't planning to do anything. It will only act when the obligation imposed on it kicks in.
Lord, I see that point. I think the answer to that point is that the Commission, of course, can itself, and this is Mr O'Donoghue's option 2, can itself, of its own motion, decide to investigate. And if it does do that, then it's subject to the same 2-month time limit. And so here it would be wrong for the for that time limit to be circumvented by Romania delaying making this point. We have had the security order in place for some period of time now, and although it's been suspended, it wasn't suspended at the very outset, but although it has been suspended, the Commission and Romania are at great pains to say that measures that are suspended nonetheless have legal effects, and we know that that's right. So the suspension of it is not a good reason not to take any action. And so our simple point is that on the Deutsche Lufthansa case law, given that they haven't yet taken action, we don't know whether they will. We think that there are formidable obstacles to the Commission taking action in respect of the security order. Then there is no duty on this court to refrain from making the security order. And in response to a point, Lord Sales, you made yesterday, we say that in any event, as was canvassed in response to a question put by you, Mr O'Donoghue's arguments, his appeal, are not a good reason, even if they're at all well-founded, to quash the security order, because the right course in our submission, given that we don't know what the Commission's plans are, it has not told this court that it is going to open an investigation, the right course would be to dismiss the appeal and see what happens. And if the Commission then, on mature reflection, decides that it's not stymied by the General Court judgment and that it can overcome these obstacles which are laid in its path by the legal conditions of what constitutes a state aid, if on mature reflection the Commission decides to open an investigation, then of course it's possible for Romania to return to the commercial court and seek at that stage, it can invoke its liberty to reply, and at that stage seek to stay the order. But it's not a good reason now to allow this appeal.
before one, quite apart from all the procedural issues there are, fundamentally, the Commission, in order to be satisfied that this was state aid, would have, in the first place, to be satisfied that it constituted favourable treatment of the Micula businesses.
Yes.
And that's where some attention has been paid to the suggestion that it might help their creditworthiness. But that wouldn't be the whole story. It then have to be satisfied that it distorted competition. And then that's not enough either. They would in addition have to be satisfied that it had an effect on trade between member states.
So, and also that it's imputable to Romania. And that's another consideration which we do not see being satisfied in this case, given that this is compliance by definition with the court order would not be a matter of Romania's discretion. And so we say within the case law, therefore not imputable to it. And that's a point which we also rely on. So we say there are a number of formidable obstacles in front of it. And my Lord also has, so I agree with all the points your Lordship's put to me, and you also have the point I made, which is that the logic of saying that this is a new aid is very much tied up with the logic of the decision which has been annulled. And so in circumstances where it appears that in relation to the final decision and the award, the Commission is not rushing to reach a new decision, but instead is waiting to see what happens with the appeal, we say it's highly unlikely that it would feel able to find that security in aid of enforcement of the award is an aid in the face of the Commission decision, the General Court's judgment finding that it had no jurisdiction. So that's another obstacle. I was going to now turn to Mr. O'Donoghue's option 3, and I can take this very shortly. So his option 3 is that the Commission considers that security falls within its suspension injunction and the decision to initiate the investigation. Now, the Court has all my points on those preparatory acts that I made earlier, but the key point for these purposes is that this is essentially the same point that was rightly rejected by the Court of Appeal, because just as security did not fall within the decision, because it's not payment of the compensation ordered by the tribunal and it's not payment of anything to the Micula parties, so too security doesn't fall within the suspension injunction or the decision to commence the investigation, which proceeded on precisely the same basis. And we see, perhaps if we could briefly turn up the decision to commence the investigation, which is in Authorities Volume 14, tab 199, and that's MS 243, starts at 243, and we see at paragraphs 25 to 26, which are on MS 248, a description of the measure. So the investigation has been opened in respect of this measure, and the measure here under assessment is said to be the implementation of the award, i.e. payment of the compensation awarded to the claimants by the arbitration tribunal plus interest. And so for the same reason that the Court of Appeal found that compliance with the security order doesn't fall within the scope of the final decision, we say on exactly the same logic, this is not an argument that avails Romania or the Commission. I'm going to now finally deal very briefly with Mr. O'Donoghue's Brexit ground. In view of the time, and because Mr. Green has some submissions he wishes to make too before our time is up, I would refer the Court to our written case where we address this ground at paragraph 65 to 71, and summarise our response in the following way. So, in answer to my Lady Hale's question, Mr. O'Donoghue said that there's a special duty that applies to an exiting member state that has served an Article 50 notice but has not yet exited. And the basis for this is said to be that if the United Kingdom leaves without a deal, then the duty of sincere cooperation or other EU law duties that are at the moment precluding on their case the enforcement of the award will fall away and the award will be enforceable. And so it said the Micula parties will achieve enforcement more quickly and easily by virtue of the fact that security has been paid, and so there's an obligation not to do that. That's essentially the way it's put by my learned friend as I understand it. The short answer to this is that the argument is extremely speculative and is not apt for proper, it hasn't been developed properly, and it's not apt really for determination by this court. And that's really for two reasons. First of all, Mr. O'Donoghue, the premise for his argument is that the United Kingdom leaves without a deal. And the court heard Mr. O'Donoghue yesterday making a series of anecdotal submissions, if I can put it that way, about the likelihood of a deal being achieved. And we say that that's simply not an exercise that the court is equipped to embark upon. And the second point we make is that even if the United Kingdom does leave without a deal, the 2018 Withdrawal Act makes certain saving provisions in respect of EU law. And there is no attempt at all, this is a point that we make in our written case, and there is no attempt by Romania to analyse at all how those saving provisions would work in this context. And so we say that on that account too, the argument's very speculative, and we note that the Commission does not support this argument in its written document. That's all I'd like to say about it. Orally, you have the submissions we've made in our written case. Unless I
put to Mr. O'Donoghue the possibility that if there was anything in this point, it could be dealt with by conditioning the release of the security. Do you disagree with that?
My Lord, no. I would say that given that we don't know, it may be difficult to draft a condition to take account of all eventualities. And I would suggest that on your Lordship's logic, if I may suggest, the way of dealing with it would be to give them liberty to apply to come back to the court once we know what the legal position is, and that the court should proceed for present purposes on the basis that the United Kingdom is still a member of the EU, which it still is, as indeed the CJU held was the proper approach in the Whiteman case. Unless I can assist any further, those are my submissions.
Lady, my Lords, two effective headings. One is to deal with Sole Bone, and one is very briefly to deal with the abuse argument made in the para 22 of my learned friend's supplemental case. That shouldn't take too long. In relation to, thank you very much. In relation to Sole Bone, can I invite the court just to go back quickly to the report of Sole Bone, which is at MS 3307. It's in volume 11, tab 166, beginning at 3303. And the relevant page for our purposes is 3307. And just to give the court context, my learned friend, Mr. O'Donoghue, at page 225 of the transcript yesterday, between line 9 of that page and 226, line 6 of the following page, drew the court's attention to the fact that in that case, Lord Justice Staunton had reduced the amount of security from $30 million to $5 million. And our respectful submission is simply this. It's not what happened, but why it happened that should interest this court. And the why strongly supports the position of the Micula parties.
Just before we plunge into Sole Bone, what do you say is the sanction for the non-provision of security? Because, of course, in an ordinary case, and I think it's true in Sole Bone, the sanction would be, if you don't pay the money in, judgment will be entered against you. But if you've lost on the stay part of the case, judgment couldn't be entered against Romania.
Well, my Lord, no. Taking it in stages, the position we ended up in the Court of Appeal was almost as an indulgence. There was no sanction attached to the order. by the Court of Appeal. So there was no sanction.
That's why I'm asking you what the sanction is.
My lord, yes. And all that followed a breach of the order was the ability of the claimants to go back to the court to seek to revive, for example, the disclosure application which the first claimant made, or to seek other relief. But we'd have to make that out on the merits at the time the application is made.
Might it not be said that Romania, as a friendly state, is entitled to know from the court order, if it's being told to do something, what the sanction should be? I mean, even if an injunction was imposed, you'd have a penal notice or something like that.
My lord, yes, but we respectfully say that Romania is in a better position than it would normally be because it's a friendly state. In this case, international comity and the EU law arguments militated against imposing that sanction.
Sorry, what sanction?
The sanction of the automatic lift of the stay. That was the conditional analysis of Lord Justice Staunton in Sole Bone.
I didn't think that was to do with comity. I thought that was to do, if the argument is right, with the obligations which arise from the duty of sincere cooperation.
My lord, I think it's right to say it's not necessary, but it's not necessary because the EU law argument on the stay would get you there anyway. I think that's fair. But it was very much, the context of the argument was very much about international comity. I did actually myself make a submission to Mr. Justice Blair that the court ought to be entitled to make an order with such a sanction that the stay automatically be lifted. But in the event, what we respectfully submit is A, there was no sanction, which put Romania in a better position than it would have been otherwise, and B, it's not in a worse position for not knowing what the sanction is. For this reason, that any subsequent consequence of that order not being complied with would be the result of a contested application before the commercial court, of which Romania would be given full notice.
I mean, isn't it entitled to know what it should be doing in order to avoid the need for such a hearing?
My lord, what it should be doing is paying security.
So would ordinary processes of execution be available against the order that the Court of Appeal made?
My lord, we submitted that they would be available subject to not going, the preliminary steps would be available. So that's why the examples that my learned friend Mr. Dimitriou gave to Mr. Justice Blair were a disclosure order and possibly a freezing order.
But, I mean, why do you even need that? If you're saying that ordinary processes of execution are available, why don't you just go and attach Romania's assets?
No, the problem is, on the hypothesis that we're not entitled to a stay, on the EU law premise we're not entitled to stay, the ordinary process of execution would not be available to us, because as Mr. Justice Blair held, you come back round full circle to what he's already found we weren't entitled to do.
I see. Thank you.
In relation to Sole Bone, at 3307, the paragraph which the court was taken to, which is, I think, highlighted on the left-hand side, the left-hand column of that page, two-thirds of the way down, if the award is manifestly invalid, there should be an adjournment and no order for security. If it is manifestly valid, there should either be an order for immediate enforcement or else an order for substantial security. And then he points out that there'll be various degrees of plausibility in between. And it's right the court should know that the reason the amount of security was varied was decisively on the merits. It was because the judge below had taken a view of the merits which was unduly pessimistic. And we see on the right-hand side on that very point, it is on point 1 that I felt the deputy judge went wrong. The contention that the arbitrator was not validly appointed is, as I have said, seriously arguable. In those circumstances, it was a very strong measure. So what was missed out in my learned friend's submission was the fact that the operative difference was a different assessment of the merits, and that highlights the importance of the merits on an assessment of this type. And we make two submissions about the merits. We respectfully say that the Court of Appeal's setting of security at 150 million was an unimpeachably reasonable number, in fact by design, more than justified by its apprehension of the overall merits of the appeal and the situation as it was. And it had heard no argument to the contrary in relation to that amount. So there was neither any error of principle discernible, nor any error on the arithmetic. But it goes a bit further than that, to borrow the words of Emperor Hirohito, that the merits of the position have developed not necessarily to the Commission and Romania's advantage. Because, of course, since the Court of Appeal's decision, there has been the decision of the General Court. And so the support for the grant of security is a fortiori to the position that we were in before the Court of Appeal. There are a couple of brief points that I'd like to make, just in relation to the other aspects of sole bone. Immediately underneath the first paragraph I went to, in the left-hand column, Lord Justice Staunton said the second point is the court must consider the ease or difficulty of enforcement of the award, and whether it will be rendered more difficult, for example, by movement of assets, etc., if enforcement is delayed. Now, that wasn't a matter on which the court had very helpful evidence, or indeed any evidence. But the further points that Lord Justice Staunton had regard to are listed at the top paragraph in the right-hand column, which is 3 points mentioned by him as relevant. One, the nature of points taken in support of the application to set aside. That's the point on which Lord Justice Staunton differed from the judge below. Two, the enormous period of time already spent in dealing with the preliminary point in the Swedish courts. And three, the apparent lack of any great enthusiasm on the part of the employers in continuing their application to the Swedish court. And essentially, one can see that on point two, effectively points 2 and 3 were points on which Lord Justice Staunton agreed the judge below was right to attach importance. And we say those are of not directly and precisely analogous weight in this case, but they clearly have a bearing on the order here. So we're in a situation where, on the application of this authority, there's neither any misapprehension as to matters of fact, nor is there any error of principle, and neither of those were argued below. So the Court of Appeal's decision can't be impeached on that footing, and the merits are now even more strongly in favour of the claimants than they were, and the basis upon which the security was varied was decisively upon the basis of the merits, the misapprehension of merits. So that's that point. Then, may I just make this point? Whilst we don't accept the omelette example of my learned friend in relation to enforcement and then taking money back, when we get to the issue of security, it's not about an omelette, it's about who's holding the egg. And in this case, there can be no proper objection to the court holding the egg. Even on my learned friend's omelette analysis. And that's a common sense point, but it's one that feeds into the analysis that the Court of Appeal made as to what was in reality being done when an order for security was being made, and departing from the submissions of Romania and the Commission in that respect. My Lord Sales mentioned yesterday the possibility of making the security order to activate the powers of the Commission in respect of such an order. And, my Lord, with respect, we respectfully agree that that is an appropriate thing for this court to do. But we would make one additional submission by way of a gloss. And it is effectively the obverse of an aspect of the paragraph in Emerald to which my learned friend took the court. I won't take the court there, but it's A9/131. Emerald begins at 2486, and the paragraph my learned friend went to is at 2516. And that's the paragraph where the court says that the judge was wrong just because the commission appeared to be breaching its duty of sincere cooperation on one street. The judge was wrong to conclude that the United Kingdom could breach its duty of cooperation going the other way. And the point that I seek to make in relation to that is this: whatever view this court may form of the mutuality of the obligations and the extent to which the Commission has discharged its side of the bargain, whatever view, that is no reason for the court not to expect and proceed on the footing that the Commission, in discharging its functions now, will respect its obligations of sincere cooperation to the United Kingdom and respect for national procedural autonomy, in particular the decisions of this court. So the right approach, we say, when considering what is likely to happen if an order for security is made, is just as the court can properly expect the Commission not only to have regard to the General Court's decision and its component parts in deciding whether to bring infringement proceedings, but it also must have regard to the duty of sincere cooperation with the United Kingdom in doing so. And that is a perfectly proper approach for this court to take in considering whether activating the Commission's powers in that way is an appropriate course. There are three particular points in relation to the GCEU's decision, which I'd very briefly like to take the court to. My lady, am I right to stop at 2:40 on the dot?
Well, you started 10 minutes early, so you
It
really
would have
should
been
be stopping at
2:35,
2:35.
and I wonder if I could have the 5 minutes my learned friend Mr. Khan had. So I did have to spend a long time on the payment point we weren't expecting. Would that be all right?
Well, as long as we finish in time,
I'm most grateful.
and as long as Mr. O'Donoghue has his time, that's...
I'm most grateful. The brief points, if I can finish before then I will, the brief points are, my Lord Reid mentioned some of the hurdles to establishing state aid. One of them was, one that perhaps wasn't mentioned expressly, was the absence of any protected legitimate expectations on behalf of the Micula parties to the aid in question. And that is, the reference for that, if it's helpful, it's the back of the core bundle at 4789. It's recital 155, and I say that again in case I misspoke and said 151 earlier this morning, but it's 155 on 4789, and that is, the claimants contend they had a legitimate expectation that the incentives granted were lawful and that they could benefit from those incentives until their scheduled expiry on the 1st of April 2009. The Commission observes in that regard that Article 14.1 of the regulation further specifies that the Commission shall not require recovery of the aid if this would be contrary to the general principle of union law, and the principle of protection of legitimate expectations has been recognised by the CJEU to constitute such a general principle of union law. The Commission does not consider, however, that the claimants can claim such a legitimate expectation. So in fairness to Lady Justice Arden, that may have been where she formed the view in 130 in relation to the exercise of the discretion, which I drew the court's attention to yesterday. And she may not have anticipated quite how strongly that clashed with the content of the award itself. But the point there is it's an additional hurdle for my Lord Reid on that analysis of the hurdles faced by the Commission, and it's one which it is perfectly clear from the General Court's decision. The General Court took a different view, and we see that at supplemental MS 494, which is in Authorities 14, 215, tab 215, page 494. It's paragraph 72 of the General Court's decision. Says, secondly, it should be noticed in that regard that the arbitral award, in the arbitral award, the arbitral tribunal concluded that by repealing the ego incentives, Romania had undermined the arbitration applicant's legitimate expectations. So any approach that the Commission takes on any of these matters has to take proper cognizance of not just the outcome of the General Court's decision, but the individual steps within it. I would only mention two other features of that decision. First of all, the point, slightly referring back to my Lord Lloyd Jones's point yesterday about lex posterior in the Acmere case. In fact, the driving force of the Acmere decision was the inability for a reference from an arbitral tribunal. And what is interesting in this case, we see at paragraph 87, which is on 896, that Acmere is distinguished on the basis that the tribunal was not bound to apply EU law. And then we also find at paragraph 77 the separate point, which we respectfully rely on just underlining a point made by my learned friend Mr. Dimitriou. In the second sentence of paragraph 77 on page 495, since the arbitral award is thus merely an ancillary element of the compensation at issue and is not as such severable from the earlier tax incentives, it cannot be classified as new aid. Now that's the basis of the General Court's decision, to which the duty of sincere cooperation of this court attaches, but also which the Commission will have to have regard to in its approach. And we respectfully say that if the award is the child, as it were, of the original aid, a security order is the grandchild or great-grandchild. So it's an a fortiori argument in relation to the ancillary point. Finally, just very briefly in relation to abusive process, I'm not sure to what extent that's really pursued with any vigour. It finds expression at supplemental MS page 12. It's tab 1 of the core volume 2, and it's just suggested there that it's duplicative, the security order is duplicative of the Court of Appeal order. The only purpose was served by repeating the CA order in this way was to circumvent the fact that it was stayed by the court. And the short point in relation to that is that the court's attention was drawn to observations by the court here, and indeed my learned friend in response to observations by the court on the 18th of June, that it was essentially dependent, the security order was essentially dependent on the stay, and therefore had fallen away. And the court will see that between page 152, supplemental MS 152 in appendix part 3, which starts at internal transcript page 30, line 12, and goes on to over the page to page 33. What in fact happened was that the court was invited to consider a stay and alternatively, in fact, made the sort of order which was precisely the sort of order made by the Court of Appeal, which was to make an order of a fixed date and leave it for this court to deal with the matter in any event. And in fact, Mr. Justice Phillips made it till the 17th, which is a week after, the day after this appeal finishes. In any event, my learned friends here on the appeal. So we don't really understand the vice complained of, and for those reasons, don't accept it was an abusive process.
My lady, I'm just rising to correct one point, if I may, that I made earlier, because I've gone back to the procedural regulation, and in response to Lord Sale's question, I indicated that the 2-month time limit would apply also where the Commission of its own motion, and I realise I misspoke because I've gone back to double check, and it would not apply where the Commission decides it of its own motion. And I just wanted to correct that point. Of course, you have our submission, which is that the Commission hasn't done anything, and there is no investigation that's been opened, and so we rely on Deutsche Lufthansa, as I've indicated, but I wanted to correct that factual.
Thank you very much.
If there's nothing I can help the court with on those points.
Looks as if you can't, Mr. Green.
Lady, my lords, obviously I will reply only on the my appeal and nothing else. And the coverage of the issues to date by the Micula parties has, in terms of balance, been more focused on the cross appeal than the appeal. So hopefully I can be a bit more brief than the time allocation. Can I start by reminding the court what is the relevant legal principle for the consideration of sincere cooperation when it comes to the security appeal? And this, I think, is the only issue of the entire case, which is common ground between the parties. And if we can pick this up first in the Court of Appeal judgment, core bundle Appendix 1, MS 4690. That's paragraph 237. Top of the page. The authorities relied on by Romania for the proposition that a national court should not merely refrain from taking decisions with conflict with the decision of the Commission, but should avoid a risk of such conflict where addressing a situation in which the decision by the Commission is contemplated but has not yet been made, and then there are a series of references to cases we have seen. Before the Commission has made a decision, it is not known exactly what its terms will be. In such circumstances, it makes sense for a national court to adopt a precautionary approach and to avoid making a decision which will give rise to a real risk of conflict with what the Commission might decide. The position is different, however, once the Commission has issued its decision. There is then no longer a need to avoid a risk of conflict with what the Commission might decide. It can be seen what the Commission has in fact decided, and so on. So that is a principle which is common ground. And just to give the court a further reference for that being common ground, if I can turn to my learned friend's written case, it's in the same bundle, MS 4498. So it's in tab 7. Paragraph 67. So this is Mr. Green's written case. Same point. In the case where the Commission has not made a decision at all, it is not known exactly what an eventual decision's terms will be. Thus, a precautionary approach is required, as the Court of Appeal recognised. However, once a decision is issued, as in the present case, the position is different because the courts can act to ensure no conflict arises. So it is common ground that where there is a vista in which the Commission can act, a precautionary approach is required, and sincere cooperation may be engaged in these circumstances. Now, what is most striking about the Micula party's response to the security appeal is that they do not actually contest that it would remain open to the Commission in a variety of scenarios or options to act in future. And just to make good that point, if we can return very briefly to the state aid procedural regulation, which is in Authorities 1, tab 5, started MS 64. it's tab 4, MS 48. So starting Article 2.1, we saw this briefly yesterday, so I can take it very rapidly. Article 2.1, there is an obligation to notify any plans to grant new aid in sufficient time by the member state concerned, and so on. And then Article 3, which is a carbon copy of Article 108.3, the standstill clause, aid notifiable pursuant to 2.1 shall not be put into effect before the Commission has taken or is deemed to have taken a decision authorising such aid. Article 4.1, preliminary examination. 4.2, the Commission may decide in that preliminary examination that it does not constitute aid and shall render a decision. Then 4.5 is important. This was rather glossed over by Ms. Dimitriou. It is not the case that the Commission has 2 months in which it must act, otherwise it is deemed to have taken a decision. The critical thing is Article 4.4. So the decisions referred to in Articles 2, 3, and 4 of this article shall be taken within 2 months. That period shall begin on the day following the receipt of a complete notification, and the notification shall be considered as complete if within 2 months from its receipt or from the receipt of any additional information requested, the Commission does not request any further information, and it can be extended by consent. Now, Romania's submission, which is unarguable in terms of controverting, is that no notification has in fact been made. And the reason for that is pragmatic and obvious. Because the Court of Appeal security order was immediately suspended, which suspension was then continued by order of this court on the 31st of October and remains pending before this court, there was no obligation on Romania to notify a plan to grant aid. Or to put it another way, as matters stand, subject to the outcome of this appeal, Romania was not planning to grant aid, and therefore the notification obligation has not been triggered yet. Now, of course, if this court does not suspend the pending security order, and if ultimately the judgment is against Romania when it comes to security, then there will, on any view, be an obligation to notify plans to grant aid. And I made clear yesterday in court, and I repeat it for the avoidance of doubt, that that is Romania's intention in those eventualities. So there can be no doubt as a matter of procedural law, as matters stand, that Romania will, in a clear and obvious scenario, be obliged to make a notification. And that being the case...
Sorry, just on that, I suppose strictly only if it's going to comply with the security order.
Well, my Lord, certainly out of an abundance of caution, the plan to grant state aid would have to be notified.
But if you weren't going to comply, then you wouldn't have a plan.
Well, Lord, our intention is to make that notification.
Can I ask if you've notified the order in America to actually pay the money?
Well, the Commission is obviously aware of that.
Yeah.
I think that has been appealed today or deadline. Whether the Commission has been formally notified, I can verify. The Commission is certainly aware, but of course that concerns a non-member state, which may be a different matter.
Well, for the moment.
For the moment, oh yes, indeed. Now, if the standstill obligation is activated, we say that is an automatic legislative consequence. It is not a question of discretion. It arises by dint of the fact of notification of the plans. And my learned friends made various valiant attempts to say, well, even if you notified, the Commission is going to struggle to conclude that this is state aid or incompatible state aid. And with respect, that is based on a fundamental misapprehension of the procedural framework and institutional competence. Because the fact of notifying and the automatic triggering of the standstill is entirely agnostic about the question as to whether ultimately state aid or compatible state aid or incompatible state aid will be found. The entire purpose of the standstill obligation is to give the Commission the time and the latitude to consider whether state aid is involved. That is the first step in the preliminary decision within the 2-month period in Article 4.4. And it is a curious submission that even in a situation where a notification was made and the preliminary decision were that no state aid is involved, which is their contention, there is somehow a suggestion that there would be some difficulty with the Commission reaching that view. But the point of procedural law and institutional competence is that it remains fully open to the Commission to agree with the Micula parties, but the critical point for the purpose of sincere cooperation is that the standstill obligation is a neutral one. It is entirely without prejudice to the ultimate answer to the state aid question, and it has the immediate consequence of preventing the implementation of the aid. And that is regardless of whether on a preliminary analysis or on a formal investigation, it turns out there is no state aid involved, or there is state aid, but it is compatible. And if we can just pick up Deutsche Lufthansa on this point, I took the court yesterday to the Self case, which is in Authorities 343, and we can pick up a similar point in Deutsche Lufthansa, which is in Authorities 5. Tab 75. Sorry, it's 74. It's at MS 1261. Now, Mr. Dimitri makes the point that in Deutsche Lufthansa there were two scenarios. One in paragraph 34 where the investigation had not formally been started, and second in 36 where the investigation had been formally started. We say in the present case the court should proceed on the assumption which I have outlined, that Romania will notify its plans to grant aid triggering the standstill. And if I can pick this up then in 36 and following, in a situation where the Commission has already initiated a formal examination procedure, it is necessary to consider which measures have to be taken by the national courts. While the assessments carried out in the decision to initiate the formal examination are indeed preliminary, that does not mean that the decision lacks legal effects. It must be pointed out in that regard, if national courts were able to hold that a measure does not constitute aid within the meaning of 1071 TFEU, and therefore not suspend its implementation, even though the Commission has just started its decision to initiate the formal examination procedure, then that measure was capable of presenting 8 elements, the effectiveness of Article 1083 would be frustrated. On the one hand, if the preliminary assessment and decision to initiate the formal examination procedure is that the measure at issue constitutes aid, and that assessment is subsequently confirmed in a final decision, the national courts would have failed to observe under Article 1083 and the procedural regulation the obligation to suspend the implementation of any aid proposal until the adoption of the Commission's decision. Then 40, on the other hand, even if in its final decision the Commission were to conclude that there were no aid elements, the preventative aim of state aid control system established by the TFEU requires that following the doubt raised in the decision to initiate the formal examination procedure as to the aid, character of that measure, and its compatibility with the internal market, its implementation should be deferred until that doubt is resolved by the Commission's final decision. And then at 41, there's a reference to sincere cooperation, and 44 to the possibility of a preliminary reference. So even in a situation where ultimately the Commission agrees with the Micula parties there is no aid, there is still a clear obligation on a precautionary basis to wait and see what the Commission decides.
That seems to simply block Romania providing the security. So as I understand this argument, the potential state aid is Romania providing the security. So if the Article 3 standstill clause applies, Romania doesn't provide the security. So that seems to meet the problem that the procedural regulation is aimed at meeting, stopping that state aid. So what would happen then?
Well, that is exactly the procedural conflict. So the scenario I'm positing is there is an order from a national court requiring security. We then have to notify. That automatically triggers the standstill, subject to the Commission's preliminary decision and that outcome. And there is a conflict between the activation of the standstill.
But that's what I'm wondering, if there really is a conflict. I mean, what do you say the sanction is if you don't provide the security? If you've won on the stay appeal, then the Court of Appeal and Ms. Justice Blair both accept that the sanction can't be pay over the money, because that would conflict with the logic for having the stay. So what do you say is the sanction if Romania doesn't provide the security?
Well, my lord, with respect, we say that isn't the right question. The question should be, if the standstill is activated, which on a notification it unambiguously would be, then the question becomes, why should a national court, given the standstill and the clear prohibition on implementation pro tem, contemplate any order whereby the state concerned is required to give security? I mean, that is the very conflict. And sincere cooperation in my submission means that order should not be made in the first place, because what it is doing is provoking an unavoidable conflict between the national court's order and the standstill obligation. And again, I do reiterate that the standstill is not a discretionary thing. It does not require a further order from a court. It is something which is triggered automatically. And it does put Romania in the horns of a dilemma. We have rude letters from the Commission saying what they will do if the security is paid. And then we have the possibility of further sanctions from a national court order in the event of non-payment.
Which are, you say?
Well, that is one of the vices of the order we have identified, which is it is unclear what exactly those sanctions would be. And we say that is a defect. But on the face of it, the order requires payment of security, and as a matter of the standstill clause, that is the matter of interest. And I mean, this is an obvious point, but the vista for Romania to be put in the scenario of potentially breaching an order of this court is a deeply unwelcome one. But we are in a difficult position where the Commission has expressed, the view it has expressed in very clear terms. We would therefore be obliged to notify on an active order being made, and then there is a collision course with the standstill kicking in automatically without the need for any further order. And in a sense, my lord, one can test this the following way. I mean, if, as I submit, the standstill is an automatic legislative procedural consequence, why should it be incumbent on Romania to come back to a national court or some other forum to obtain an order to lift the thing which, in breach of the standstill, should not have been put in place to begin with?
Yes, thank you.
Now, while we have Deutsche Lufthansa open, can I just make one quick point? tab 74, bundle 5. Now, my Lord Hodge made a perfectly valid and fair point of criticism, which is that mutual trust and sincere cooperation is a two-way street, and each side has to act in a way that furthers those interests. And we entirely agree with that. And again, from Romania's perspective, the delay engendered by these proceedings is something it regrets. And from Romania's perspective, a lot of bandwidth and state resources have been taken up in multiple litigations all around Europe and elsewhere. This is not a position Romania wishes to be in. But in my submission, that concern is understandable and is well taken. But when it comes to sincere cooperation, it is important not to put the cart before the horse. And the starting point must be, what is the procedural obligation, if there is one, involving sincere cooperation? And if it is on analysis, the activation of the automatic standstill, which deactivates the role of the courts at a national level, apart from securing the standstill, and then activates the Commission's role, then the delays that are inherent in that procedural route, they are a necessary, if unwelcome, part of the practical application of sincere cooperation. So to put this in Deutsche Lufthansa context, the court will see from the head note, the judgment was rendered in 2013, and if one looks at MS 1257, so the paragraph 14, so the first litigation at a national level was in 2006, paragraph 16, Commission decision in 2008, and then a domestic appeal in paragraph 15, and then a reference to the Court of Justice. So in this case, there were, for various reasons, substantial delays, and yet, notwithstanding and cognizant of those delays, the Court of Justice was clear in my submission as to what sincere cooperation, and in particular the standstill, required in that context. So we do make the point that delay is to be deplored and is something we have sought to avoid, but if sincere cooperation requires a certain course of action, provided the Commission is acting in a way that is normal and diligent, one should not put the cart of delay ahead of the horse. Now, I've made the point that if on analysis the activation of the standstill is engaged, then whether and to what extent the state aid conditions are satisfied is at that stage a matter for the Commission, if only as I indicated, because the Commission may ultimately agree with the Micula parties that there is no state aid. So it is agnostic as to that possibility. So there were a number of valiant attempts by the Micula parties to say, well, this condition and that condition might not be satisfied in this case. And one answer to that is, well, they may well be right. The Commission may, when its feet are held to the flames, agree with the Micula parties that on analysis there is no aid involved. All we know today is that is clearly not their view, but this is something they will have to decide in a proper way. And one outcome of that, one possibility, is that in the end they agree with the Micula parties. So that, with respect, is not a point. The activation of standstill is agnostic as to the underlying issues. That is the Commission's job, and if the Commission has got it wrong, there are remedies available to the Micula parties and other parties in that eventuality. But I do want to pick up on a couple of points, because it's been suggested that we haven't addressed our minds to this at all. And for example, one of the points suggested was that there would not be an effect on trade. And with respect, if one looks at the decision, it's in core volume appendix 1. MS 4784. We saw this actually a couple of days ago, and it's 123 of the decision, MS 4784, and the basic point made there is that the Micula undertakings are competing on European-wide markets against other entities, and I made the point on Monday that that may include UK companies, and therefore the aid to them was found to affect trade between member states. These are foodstuff producers. Now, if one thinks of the security amounts, these are substantial amounts of money. Mr. Green and Mr. Micula have rather retreated from their own evidence that these security monies could be used to bolster their credit position, both in terms of securing loans for the companies and in terms of taking litigation funding off the companies' balance sheets and obtaining funding from third parties. Now, on any normal analysis, these are competitive advantages granted to undertakings operating, as we see, in competitive liberalized markets. And one does not need a lot of state aid imagination to imagine that these are monies capable of conferring an advantage on the Micula undertakings active in these markets. Another point which was taken is that this would not be imputable to Romania. And as to that, we say, well, if Romania is paying a substantial sum of money, of course it's imputable to Romania. Who else would it be imputable to?
The only difference between the existence and non-existence of security is this. If there is no security, then Romania, as a friendly state with assets, you would say, is perfectly able to meet an award if it is entitled to do so under EU law. With security, the money is provided into a sealed fund, as it were. So one doesn't have to go through enforcement procedures against the assets of the Romanian state, which are not protected by state immunity. That is really the only difference between the security and the other circumstance. And is it being suggested that that amounts to aid which distorts inter-member state trade?
Well, Lord, there's an element of Turkey's arguing for Christmas with me making these submissions. Romania does not want to be in the position of granting incompatible
Of course not.
state aid. But to answer your question, I mean, again, if one goes back to their evidence, we can use the security to get loans and funding that directly or conceivably improves their competitive position. In response to my Lord Reed's question, well, by the same analysis, it has the capability to distort competition in state aid terms. It is a source of funding that other undertakings competing with the Micula undertakings would not be entitled to. It is selective to that extent, and £150 million in any person's language is a substantial competitive advantage. Now, again, these are all matters for the Commission. They may ultimately agree with the Micula parties, but there is certainly a highly credible basis on which one can conceive that £150 million of security is capable of giving rise to satisfaction of the state aid conditions.
I can see that security as against a debtor whose covenant was poor. The difference between the position with or without security would be very clear. But where the Romanian state is clearly capable of meeting these sums, and it is being said that the obvious thing to do is for the Micula interest to pursue the Romanian state in Romania, then the added value of security is perhaps questionable.
Well, I take that pragmatic point, but in a sense, my submission is that the state aid analysis would be entirely agnostic as to that practical non-difference. The point of interest would be at the point the security requirement is imposed, at that stage, is there something which one could conceive of as an advantage? And if the answer is yes or potentially so, that is sufficient, even if there may be other scenarios in which similar payments could be achieved in Romania or elsewhere in other ways. So in other words, one doesn't counterfactualize the state aid analysis. One looks at what has been granted, and one doesn't compare that to what might be obtainable on a different hypothesis. I can pick up on a handful of more discrete points. On Sole Bone, Mr. Green said that the critical point in that case, or one of them, was that the challenge to the award in terms of the merits was a seriously arguable case. And we do submit, based on the outlined submissions of Mr. Khan, that it cannot fairly be said that the Commission's appeal to the Court of Justice is not seriously arguable. There was a passing attempt in Mr. Green's supplemental written case to suggest that the prospects of the appeal for the Commission were act clair against the Commission. I note he was careful not to repeat that on his feet. And with respect, that would be a hopeless submission. The Court has seen in outline terms the 44 pages, 124 paragraphs of the Commission's appeal. Mr. Khan took you through the Europe Agreement ground of appeal. On the face of it, that is something which was active accession ground of appeal. On the face of it, there was a clear temporal carve-out in that for aid that would otherwise be pre-accession. So this is a credible appeal, and to the extent Romania needs to show as part of its security appeal that that appeal is seriously arguable, we say that threshold is satisfied. Mr. Green made a further point on legitimate expectations, and in my submission, what he has done is wrongly conflate a legitimate expectation as a matter of bilateral investment treaty law, which is one thing, and where there are findings we accept, and the separate question under state aid law as to whether it is a defense to what would otherwise be unlawful state aid to say that its payment should be permitted on grounds of legitimate expectation. These are two different legal issues, and it is wrong to conflate them. On the so-called Brexit ground, 2 points if I may, Mr. Dimitriou's first submission was that the prospect and terms of the United Kingdom's withdrawal are insufficiently proximate or crystallized for this court to take any view either way. And with respect, we say based on the Oro case, which is a judgment already rendered, the Court of Justice has clearly decided matters based on the Article 50 notification and its strict legal terms. And Ms. Dimitriou, her second point was that the submissions we made on the consequences in terms of withdrawal were anecdotal, and with respect, that is incorrect. They are a matter of law. As matters stand under the First Act of 2018, combined with the more recent so-called Benn Act, the dates of leaving are long stopped, and the terms on which the United Kingdom would leave as matters stand are equally crystallized. So we do say that point is proximate and crystallized enough for this court to form a view. A couple of final points. In response to my Lord Sale's point yesterday and today about the terms of an order requiring one or more parties to come back to the National Court and following the Commission's preliminary investigation, we say that the matter could be put in a slightly different way, which is the order could be drafted in such a way that Romania would suffer consequences if it did not make the notification which I've outlined, and that there would be a liberty to apply at the end of the 2-month preliminary investigation period, and the matter will be addressed at that stage, depending on what the Commission has decided. So if, for example, following the 2-month notification, the Commission agrees with the Micula parties that there is no state aid, that would be one thing. If the Commission has a different preliminary view, that may be another thing. And we would suggest that, given the mandatory and automatic consequence of the standstill, the sequencing of the order, if one is made, should be done in that way. In other words, because the standstill is an automatic legislative consequence, it should not be incumbent on Romania to then seek a further order from a national court activating or deactivating the standstill. That is something which, if notification is made, should be contingent on what the Commission decides as a Romanian matter. A couple of final points, if I may. Very briefly on payment. I mean, I sort of, payment has grown like Topsy, and I'm afraid it's my fault. So let me try and clarify matters. First of all, it is no part of my appeal, and never was, that I'm seeking to reopen amounts paid or not paid below. I'm not taking those points. The minimalist point I made, which was to record a fact, is that the Commission is, or was, pursuing infringement proceedings against Romania for having paid 92 million euros. And that is part of the matrix before the court. Now, in terms of Mr. Green's table, I will try and be helpful where I possibly can. So if the court has that in front of it, so here's items 1, 2, 3, 4. On item 1, it is agreed, subject to an important point I will come to, that is, in ballpark terms, the underlying award at that date. And 2 and 3 go hand in glove. There is a receipt of about 8 million and then a recovery of a smaller amount. That can be taken as common ground for purposes of today. Now, the 2 qualifications which are important, but ultimately unsatisfactory, I suspect, are as follows. So the first one I've mentioned is that Romania has today, or will certainly by tomorrow, appealed the District of Columbia judgment, which found no payment, and that is the subject, or will tomorrow be the subject of an appeal, so that remains at large. And the second point is on the question of tax offset. So the court will recall that there's been reference to a Romanian Supreme Court proceeding on the legality of the tax offsets, which was stayed because of the Commission proceedings. That case has been reactivated following the General Court judgment and will be heard early in 2020. So the legality of the tax offsets will be reactivated at that stage. And I mean, I don't wish to preempt what may or may not be decided, but this is an important point in the following sense. The basis of Romania's contention in the United States that the award has been paid is to do with tax offsets, including substantial penalties for non-payment of tax by the Micula parties. And our case will be that if, as a matter of Romanian domestic law, those offsets were lawful, the award has been satisfied. Now, I don't wish for 1 second to invite the court to engage in any of that, but I am duty-bound to at least explain to the court some of the possible future events which may be happening in Romania in particular. That's all I wish to say about payment. 2 final points before I sit down. First, I'm sure the court will have well in mind that my application for suspension of the security order of Mr. Justice Phillips remains outstanding. And 1 final point, there was a reference by Ms. Dimitriou to a new case she had not addressed in her opening, which is the Patman-Nice case. And can I just give the court 1 reference to where we've dealt with that in our written case? It's in core volume 1, tab 6, and it's 186, it's MS 4464. And it starts about a third of the way down. The claimants accept that the courts will be bound by the EU court's findings of the application of Article 351 if they were made in the context of infringement proceedings. Apparently not otherwise. This does not make sense since the EU courts could be easily seized of the same issues in multiple types of proceedings, simultaneously. Distinction drawn is thus entirely arbitrary and would make a consistent and effective application of EU law contingent on the happenstance of the procedure. A procedural race to the court should not fundamentally alter the application of the same principle. And then the reference to our response to the Patman-Nice case is footnote 316, just so the court has the complete picture. Those are my reply submissions, unless I can assist you.
Thank you very much indeed, Mr. O'Donoghue, and indeed everybody who has not only addressed us, but also done the preparation which will have helped those who have been on their feet. I feel sure an awful lot of work went on by people who are sitting behind those whom we've had the pleasure of listening to. We shall now go away and try and work out what we think the answer is. I'm not sure that I could guarantee that we could produce it before the 31st of October.
Lady, the party's appreciation for the courts accommodating this appeal again was expressed before Mr. Justice Phillips, but in case you don't chance upon that bit of the transcript, can I say thank you on behalf of all parties?
Thank you, Mr. Green. That doesn't often happen. So thank you. The court will now adjourn.